Welcome to Immigration Insider with your host, attorney John Nicelli. This podcast is an educational forum on how to deal with complex aspects of immigration and pitfalls to avoid. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Now here's the host of Immigration Insider, attorney John Nicelli.
Hi, everyone. I'm John Nicelli. I'm an immigration lawyer in New York City, and I've been practicing exclusively in the field of immigration law for more than 40 years. Today, we're doing this podcast because we want to speak about a new ruling that came down just on June 17th. So President Biden decided to sign an executive action, which is commonly known as the keeping families together. So keeping families together was a great idea in theory, but unfortunately, it's already been challenged. Currently, we don't know the extent of the law, if it's actually going to go through, but what they've told us is that you can file applications, continue filing applications, and immigration will actually process those applications, but they are not going to approve the application. So they're going to accept them, but they're not going to adjudicate them. So it's just to do normal filing online. Everything is online. And after they receive it, it'll sit there God knows how long until this lawsuit is over with. The lawsuit was filed in Texas. It's joined by, I believe, 15 states, challenging Biden's authority to implement this ruling, which is an executive action. I believe that President Biden has the authority to do this type of executive action, like many presidents have done things in the past, but for whatever reasons, it's being challenged. And once a challenge starts and is filed in court, you can rest assured that it's going to probably be for many weeks and probably many months and even many years in motions and appeals and whatever. So I don't think that it's actually going to go into effect for quite some time. If it does, we hope that it does, but we really don't know right now. So right now, we encourage people just to file, and I'm going to go over all the criteria for filing, and we'll see what happens. So, but it's very unfortunate. So anyway, as far as I'm concerned, I believe President Biden has done the right thing because, according to government studies, this executive action is going to help approximately 765,000 non-citizens who are married to U.S. citizens. So these are people that have been residing in the country, married to U.S. citizens, probably have families here, but unfortunately can't legalize their status because they entered illegally. And it's going to also affect stepchildren because if you're a stepchild, you can benefit as well. So basically, this is what's required. You have to show that you entered the country unlawfully. So you're in the United States without admission or parole. You didn't come through an airport. You didn't come through a port of entry like on a ship or anything like that. You just entered unlawfully. Somehow you got here across the border. So you were never inspected, whether it be at a port or at an airport or even at a port of entry or at a border crossing. You were never inspected. So you must be in the United States without admission or parole. A lot of people come with visa waivers, which is many Europeans for 90 days. And then after the 90 days, their visa expires if they stay here. The same if you entered as a B2 visa as a tourist and you overstayed. Well, if you were inspected, even though your visa has expired and you overstayed, you were inspected and do not qualify for this law. All right. You have to show continuous presence for at least 10 years. So the law was signed on June 17, 2024, which means you have to show physical presence from June 17, 2014. That means that for every year from 2014 to 2024, you should have a number of documents verifying that you stayed in the United States and did not leave the United States, that you were physically present here. And I'll go over some of the documents that they'll accept. You have to have basically been married since before June 17, 2024, then you have to be married to a U.S. citizen before June 17, 2024. So your wife had to be a U.S. citizen on June 17, 2024, or actually June 16, 2024. And you have to have no disqualifying criminal history, which I'll also go into a little later in this podcast. And you must meet a favorable exercise of discretion. And what that means is basically that you're applying, you have no criminal history, no bad immigration history, and as a matter of discretion, you're deserving of becoming a permanent resident of the United States. So it also applies for stepchildren, but for stepchildren, it's a little different. To meet the definition of a stepchild, you have to be married to the parent of that child before that child's 18th birthday. So if you're married to the parent before the child's 18th birthday, then the stepchild would qualify. However, the stepchild does not have to show physical presence for 10 years. The stepchild only has to show that they've been in the United States before June 17, 2024, all right, without admission or parole. So the child could have entered at any time without admission or parole before June 17th. So they could have came 2016, 2015, 2014, whatever, but they do not have to show that they were physically present for 10 years, only the parents. Now, the purpose of this law was basically to promote family unity. And immigration has always had actually a good record of trying to promote family unity. And basically that means they want to keep families together. They don't really take any pride in cases taking years and years and years to be adjudicated. In fact, many times immigration would like to do them as quickly as possible. I know many people that work for immigration, and they're just inundated, and as a result, there's many, many delays. But the purpose of the law is to promote the family unity, to reduce these backlogs of people waiting. For example, if you're from, say, from Mexico, and your brother or sister is an American citizen, and filed for you, well, you're going to wait probably about 20 years in processing time, if not more. If you're from one of the European countries and your brother or sister who's a citizen files for you, you're going to wait at least 15 years, all right, which is a long, long time. So, and if you're married to a citizen, probably if you're eligible to, if you're not eligible to adjust status, meaning that you entered illegally, there's no way you're going to get your green card in the United States. You have to leave the United States. So immigration had put in effect another process for what they call an unlawful, provisional unlawful presence waiver. So that waiver is available to people who have one entry into the United States, who entered illegally, and are married to citizens or residents. The problem with those waivers is that you can be forgiven for unlawful presence, but you must be processed at the American consulate or embassy abroad. So wherever you're from, that's where you have to go back to. Most of the time, you only have to stay there for a few weeks and you can come back, so it's okay. But it does involve going overseas. And many times there have been cases, I've had many cases where people have been denied visas abroad, and I get the case after they've been denied a visa, and they have to overcome whatever that the reason for the denial was, if they can. And, you know, most of the time we get the people back, the overwhelming majority of the times, unless you have some bad criminal history. But all that could be avoided if it was done right to begin with. So that's always a risk when you go overseas. The other reason that immigration, the reason why President Biden put this law into effect and all the people that are involved with him, it actually is going to further U.S. interest in managing the flow of people going across the border. Because the more people that are legalized here that are married to citizens, well, that's less people that be crossing the border illegally. And that it actually helps economically, because then they'll take a plane or to drive across, or a bus or public transportation, whatever, you know, to go across the border rather than across the border illegally. So it does actually help economically on both ends. And then when people go and visit their foreign country or a foreign country, because they're not legal, they're going to spend money in that country. So everybody benefits in the long run economically. And another reason for it is that it's going to reduce the government resources. So if people are legalized here, it reduces resources that are needed to legalize people at consulates doing these waivers, these provisional and lawful presence waivers. If people are not going there not to do the waiver, you don't need the people to do them. So they can concentrate on other things which are necessary. It also reduces the amount of manpower that ICE would need to look for people, arrest people, prosecute people. And it also reduces the amount of time that the courts need, because the courts don't have to have a court case to deport here, have a hearing regarding a deportation or removal, because now that person is legalized. So all of that gets avoided. And in many, many, many ways, it's beneficial to all parties involved. And it's also a national security issue because people have to do background checks. And if you do background checks, and they're cleared, it shows that they're fine. They don't have any major arrests, and there's really no big deal. So that's what's really important. Now, one of the things that you cannot do, as I mentioned earlier, if you enter legally, you cannot apply. You're not eligible. If you have a serious criminal conviction, you have a drug conviction, you have some kind of bad criminal history, maybe you've been in jail a few years, you did robberies, assaults, or murders, or whatever it may be, probably not going to be eligible. And basically, you can't be a threat to or pose a danger to anyone in the United States, or a threat to national security, or to public safety, or even border security. So another thing I wanted to tell you is that a lot of people have come to me and they've said, oh, I've been here for many, many years. I'm married to a citizen, but I can't get legal. And then they find out that they have multiple entries across the border. So one of the problems is that if you're subject to having multiple entries, you're probably subject to what they call 212A9C of the Immigration and Nationality Act. What that means is that, say a person came here and they stayed here unlawfully for at least 6 months. And after they're here a period of time, more than 6 months, they leave. Now, technically, under the law, if you come back, you're barred for 3 years from getting your residence. And if you stayed here 1 year unlawfully and came back, you're barred for 10 years from getting your residence. And that's the purpose of the unlawful presence waiver. But that only applies if you entered once and did not leave the country and then come back to the country. So if you entered once illegally, stayed illegally, never left, you're eligible for a waiver. But if you didn't, you're not. So that's a big problem. So many people have had multiple entries because they went back to their countries for family matters. Maybe a family member was sick. Maybe they died. Maybe a special occasion. It could have been a birthday. It could have been a wedding. It could have been almost any reason. But if you made that second trip where you came and left and came to the United States a second time, you're barred for pretty much 10 years if you stayed here over 1 year. So also, there's other issues that are involved because everything is a matter of discretion. And let's say you came to the border, and when you presented yourself at the border, you had fake documents. Or you may have given a fake name, you may have given a fake date of birth, a totally fake identity. Maybe you had some other person's documents. There's many other reasons. That's a gross misrepresentation. That in of itself can be a denial of getting permanent residence, and it could also be denial of getting parole in place because of the misrepresentation. So you really basically have to have no disqualifying history, whether it be an immigration history or a criminal history. And as I said, the criminal history, they're pretty strict on that stuff. They do background checks, and they will do background checks on everyone. So they will verify what that person has done, whether they've been to jail, how serious the crimes were. Do they have multiple crimes? Maybe they have 2 or 3 DUIs. I mean, that's a big problem. Maybe they committed a crime. They were accused of a crime that they said they didn't do. Well, if they didn't do the crime, they pled guilty because they maybe didn't understand the court proceedings or the lawyer that they had. Many times a legal aid lawyer will say, listen, they don't even speak the language. So they said, no, just plead guilty and we'll get you out of court right away. And people say, I just want to go home, so I'll plead. I don't care, as long as I'm not going to jail. Well, in that case, what you'd have to do is go back to court and you do what they call a 440 motion to reopen the case to to get the conviction overturned, basically. And then if that happens, then you would be okay. But that, again, depends on the circumstances of exactly what the surrounding circumstances of the arrest and what happened as far as the court proceedings are involved. Another thing, if you're in court proceedings now, so many people are in court proceedings because maybe they filed for cancellation of removal, maybe they filed for asylum. Well, currently, immigration said they're going to accept those applications, and when they are if they're ever able to process them and adjudicate them, then if you're in court proceedings, and they may still approve the parole in place. So if they approve the parole in place, then at that point, you'd have to go back to court after it's approved and tell the court judge they were proof of parole in place and they want to refile, they want to reopen their case so that they can, or if the case is still pending, they want to close their case in order to file for adjustment of status. And you can file adjustment of status before the court, or you can file before immigration. So it gets a little complicated sometimes with what I'm telling you, but basically that's what the procedure is. Now, even if you have an old order of deportation, immigration said that they may review the application. Doesn't mean they'll approve the application because everything is a matter of discretion. I would think if you have an old order of deportation that's probably 20 or 30 years old or more, I would think immigration might consider that fact. And as a result, especially if you have a family here, and they may actually approve the parole in place. But if they do, you'd have to go back to the court, reopen the deportation proceeding or removal proceeding, and then ask the judge to allow you to adjust status in the United States. Basically, understand one thing, that this is not guaranteed. And by filing this, you are subjecting yourself to immigration's telling them where you are, what you're doing, all your life history, basically, or at least part of it. And with that, it could, if your case is denied, it could lead to removal proceedings. Under the Biden administration, I don't believe, if cases were approved, that they will actually, if cases were denied rather, that they will put you in removal proceedings. However, if there's a new Trump administration, I can almost guarantee you, if your case is denied, you'll be put in removal proceedings. So it's a big risk. If you're not certain what to do, then I would say don't do it, because that could happen. As far as proof of physical presence, basically you have to show your marriage certificate, you have to show your birth certificate, and you have to show that you've been living in the United States for 10 years. So what will they accept for 10 years? Well, rent receipts, mortgage payments, utility bills, driver's licenses, church records, bank statements, insurance policies, maybe W-2s, employment records, doctor or dentist letters, medical records. Maybe you received, you were in school, you received an award or a certificate. Junk mail you receive at home, any mail that's postmarked, anything like that will probably be accepted. But remember that you can't just submit one document for each year. You'd have to submit, and you can't submit like 500 documents for each year, because immigration is limited on the amount of documents that they will accept. So realize that I would suggest that you file at least one, maybe 2 to 3 documents, for every quarter. So maybe one document a month, one document every other month, something like that. But you should have enough documents to convince immigration that you were here 10 years and never left, because that's what they're concerned about. Did you ever leave? And do you have more than one entry? Now, another issue with this parole in place is that there is no appeal. So if it's denied, there is no appeal. You cannot go to immigration court. You cannot do any appeal. What you can do, if there's, I don't know what the grounds for denial were, but if there were minor grounds, perhaps you didn't have enough documents, well, there's nothing that says you can't refile. So you would just refile in that case. And that's pretty much it. And another thing is that you must file everything online. Everything you have to create an account online with USCIS, and all documents have to be uploaded and filed online. You cannot mail this application to anywhere. You have to now only file online, but you have to pay the filing fee. All right, and I believe the filing fee is now $760, right? Oh, $580. I'm sorry, it's $580 right now, and that's basically it. So you must file online, pay the filing fees, upload the documents. So with that, I'd say congratulations to everyone. If you hopefully will get accepted, but we don't know if that's going to happen. We hope it does. As I said, it's in litigation right now. It may stay in litigation for years to come. We really don't know. But if any questions, feel free to call my office. My number is 227-8020. As I said earlier, I only do immigration law the last 43 years, and if I can help you in any way, I'd be happy to. All right, thank you very much.
You've been tuning into Immigration Insider with your host, attorney John Nicelli. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.